and good morning to dignitaries, my dear participants and students. Welcome to e-platform of GLS Law College, Faculty of Law, GLS University. It is truly said by Mahatma Gandhi that all the world over true peace depends not upon gunpowder but upon the pure justice. In ensuring the justice, the judgment should include four aspects like independency, impartiality, fairness, and the competency. Considering the importance of the judgment writing skills, today we have gathered for an expert session of Honorable Miss Justice Harsha Devani, and which will be followed by the result declaration ceremony of Virtual National Judgment Writing Competition 2022. Now, I would like to invite the backbone, the powerhouse of GLS Law College, Faculty of Law, GLS University, the director, Dr. Mayuri Pandya. Ma'am, for her welcome address, of course, and for ma'am represent at herself and the institute at various platform like Export Appraisal Committee, Export Appraisal Committee, Gujarat Chamber of Commerce and Industry, and at PICI, and many more in the list. Ma'am, over to you.
Thank you, Jia. It is indeed my pride and privilege to welcome Honorable Miss Justice Harsha Devani, a synonym of humility and an exceptional judge, exceptional justice who has a keen interest in academics. Ma'am, on behalf of GLS College and the GLS University, I welcome you to this e-platform. We are fortunate that you have accepted our invitation, and this is for all my students and everyone who have joined today. I welcome each one of you today at this special expert session. We at GLS University, we always endeavor to inculcate the required skills to the students, especially for this, because the law is a professional course, and for that it is very essential to develop the skills of advocacy, or to, if we say, for the judgment writing as well. So every year we have this competition of judgment writing competition, wherein the students across the country, they participate in this event. And the most important part of this event is for all of you, especially all the students, because you have participated, irrespective of who is going to get who will be the first or the second. The most important part was that you have participated. Honorable Miss Justice Devani ma'am and Honorable Mr. Justice A.L. Dave sir, both of them were the backbone for this entire our event, because ma'am has accepted to be with all of you and to guide you by her expert session, and by declaring the result today. And A.L. Dave sir, due to the paucity of time, he could not be with us, but he checked, and I'm proud to say that all of you have, they said that being a student to write these kind of judgments, it itself is that we remember that after joining as a judge and to be elevated at the High Court, I think that being a student, I would have not been able to do the justice, what justice the students have done. So I think that it is really commendable, and we appreciate all of you that you have participated in this. Your participation itself is a prize. But every event, it's we have to declare the result. So this ceremony has to be as a part of procedure. We have to do that. But for us, you all are the winners. I welcome each and everyone who have joined today with us on this e-platform, and especially ma'am, you are always so kind, and you always accept our invitation, and you're always there. It shows your sincerity and your sincerity towards the profession. The reason being, I'm saying that towards the profession, because if you talk with students and you interact with students or you interact with the advocates, the amount of inspiration they get is, I mean, I cannot put it in words. So when you accept and would like to appraise all the participants who have joined today. Today morning also when ma'am joined, she said that I don't mind, even my session is on the judgment writing, but even if students wish to ask any question relating to advocacy, any question relating to the legal profession, any confusion, any question, any query if they have, then they can join. So this is what I don't need to say more about ma'am for her keen interest and especially devoting her time for the students. Once again, I welcome each one of you and I wish you all the best. As I said, each one of you are the winners, but still the moment is always awaited to know that who are the winners today. And I mean, it's more than a 1 month, I think, Vidhi, if I am not wrong. So I can understand your excitement and patience. Appreciate the patience. I welcome each one of you today, and thank you. Thank you very much.
Thank you, ma'am, for such a warm welcome. Now, I would like to introduce alumni of GLS, Honorable Miss Justice Harsha Devani. Ma'am is the former judge of High Court of Gujarat and was elevated as an additional judge of Gujarat High Court in the year 2004. Ma'am hold the master degree in science from microbiology from the University School of Science, and then her ladyship pursued LLB from Sir Elisha Law College, Ahmedabad. Ma'am enrolled as an advocate with a Bar Council of Gujarat in the year of 1992. Ma'am's rich experience reflects in her tenure as an assistant government pleader and additional public prosecutor. Her moral excellence and analytical skill enabled her to have a mastery in constitutional, civil, and criminal matters. She was one of those judges who heard the appeals in the 2002 Naroda Patya case. Ma'am's Ma'am, students are eagerly waiting for your expert session on art of judgment writing. Ma'am, over to you.
Thank you. A very good morning to all of you. It is indeed a pleasure to deliver this lecture on art of judgment writing. I believe this is an audience comprised mostly of students who generally do not have to write judgments except for such competitions. So I don't know how much of what I speak will be of any use to you. Nonetheless, let me make an effort. The topic is the art of judgment writing. But is judgment writing an art? I guess it is. But not all judgments are works of art. Some judges have a flair for language and marshalling facts very succinctly in a manner whereby even something quite ordinary sounds interesting. Their judgments are actually works of art. However, only some judges have the ability of writing such judgments. One name that instantly comes to mind is Justice Krishna Iyer, who had a flair for writing judgments which were exceptional and different from the judgments written by majority of the judges. Just like all of us can draw and paint, but not all of us can be accomplished artists. Not all legal writers have the stature, the skill, or the ability of such judges. But one can learn from such gifted writers and emulate them by studying the finer points of judgment structure. Let me cite an extract of some judgments of Justice Krishna Iyer to demonstrate how artistic a judgment can be. These are only opening paragraphs. I quote from State of Punjab versus Gurdayal Singh, 1980, 2 SCC, page 471. I quote, "Every meritless petition for special leave commits a double sin, and here we are, scandalized that the sinner is the state itself. When thousands of humble litigants are waiting in the queue, hungry for justice, and the docket-locked court desperately wading through the rising flood, every lawless cause brought recklessly before it is a dubious gamble which blocks the better ones from getting speedy remedy. Here is an instance." Then I may quote from Baldev Raj Chadda versus Union of India, 1980, 4 SCC 321. The appellant, an accounts officer, compulsorily retired B times, appearing in person, has painstakingly and proficiently presented his case, which calls for mercy, if not justice. Obsession with one's own case and inability to see things in perspective are often a frailty of a party who spends the enormity and anguish of his superannuated leisure on the main pursuit of his litigative points, and this makes for prolixity and subjectivity of submissions, which are not the persuasive but the provocative part of the art of advocacy. Even so, we have listened with sympathy to the studious orality and read with patience the manuscript arguments emanating from the appellant. Now, this is an ability which very few judges have. But a judgment, to be a good judgment, need not be a work of art. It may be written in simple language, but the main aspect is that it should be clear, lucid, and written in a manner which even a layman can understand. If the judgment sets a precedent, it should come out clearly, and the reader should be able to easily understand the ratio of the decision. Judgment writing does not begin with dictating the judgment. There is a lot of groundwork that is required to be done before attempting to write a judgment. Therefore, the first step towards writing a good judgment is a deep study of the case. Now, what do I mean by deep study? You have to really prepare the case, which includes reading the case papers, that is, the pleadings, the evidence, both oral and documentary, thoroughly, and be fully conversant with the facts. Then you have to minutely read the legal provisions, analyze them, and study the applicability to the facts of the case. Then, at the stage of arguments, you should give due hearing to the learned advocate for the respective parties. Unless you hear them, you would not be able to understand the point of view they want to put forth. At times, when a judge reads the case papers, he may form a belief that the matter is without any merits and deserves to be dismissed in limine. But upon hearing the learned advocate for the party, he or she may be convinced otherwise. Therefore, hearing the case fully and properly is necessary to arrive at the correct decision, and it also becomes easier to write the judgment. At the time of writing the judgment, one has to marshal the facts and apply the law to the facts. The applicability or otherwise of the legal precedents cited by the advocates to the facts of the case has to be considered. Towards this end, it is necessary to read the relevant judgments cited by the parties fully to understand the ratio decidency of the decision correctly. Never go by head notes, which are not actually a part of the judgment, but written by experts of the law journals. At times, when you read the entire judgment, you will not find what is stated in the head note anywhere in the body. Besides, unless you read the decision in the context of the facts, it is difficult to understand what is actually held by the court. To be able to express yourself well, you should be armed with a good vocabulary. Good vocabulary comes with reading. The more you read, the more you learn. Reading well-written judgments or other books, even fiction, can help you in improving your vocabulary. Well-read people can appositely quote Bernard Shaw, Shakespeare, and other reputed writers and make their judgments more interesting. But you have to be really very well-read to quote in a manner that is opposite to the situation. It should come naturally and not appear contrived. I may quote an example where a judgment is made really interesting by quoting other authors and poets. This again is an extract from a decision rendered by Justice V.R. Krishna Iyer in the case of Maru Ram versus Union of India. I quote, "A procession of life convicts, well over 2,000 strong, with more joining the march even as the arguments were on, has vicariously mobbed this court through their learned counsel, carrying constitutional missiles in hand and demanding liberty beyond the bars. They challenge the virus of Section 433 capital A of the Criminal Procedure Code, which compels caging of two classes of prisoners, at least for 14 eternal infernal years, regardless of the benign remissions and compassionate concessions sanctioned by prison law and human justice. Their despair is best expressed in the bitter lines of Oscar Wilde. I know not whether laws be right or whether laws be wrong. All that we know is who lie in jail is that the wall is strong and that each day is like a year whose days are long. But broken hearts cannot break prison walls. Since prisons are built with stones of law, the key to liberation too is in law's custody. So counsel have piled up long and learned arguments punctuated with evocative rhetoric, but judges themselves are prisoners of the law and are not free to free a prisoner save through the open sesame of justice according to law. Even so, there is a strange message for judges too in the rebellious word of Gandhiji's posse guru, David Thoreau. The law will never make men free. It is the men who have got to make the law free. They are the lovers of law and order who observe the law when the government breaks it. The case of the petitioners is that Parliament has broken the law of the Constitution by enacting Section 433, capital A. Now, how many of us can quote Oscar Wilde and David Thoreau? For being able to do so, one has to be really well read and should have the ability to recollect what one has read. I have seen some colleagues able to recollect passages word by word, which is a special gift which many of us do not have. While writing a judgment, use plain language. Judgment should be easy to read. The use of plain everyday language helps to achieve this. Unless there is a need for it, technical language and legal jargon should be avoided. This does not require judges to resort to an artificial simplistic writing style, but rather to use the normal and sensible words and phrases. Each judge has an individual manner of expression. Judgment should be expressed in a language and style which suits the decision maker. It is generally better for judges to write in their own style rather than mimicking others, which does not come naturally and is bound not to read naturally either. It is sometimes suggested that style should not be confused with substance, and that in writing judgments, it is the substance rather than the style which is important. Write all words in full and don't use abbreviations, except where one refers to an enactment in short form or a name which is too long. Don't use expressions like Jan, Feb, etc., or don't use slang. While referring to decisions cited by advocates, refer to the names of the parties as well as the citation, and refer to the reasons given in the body of the judgment. Don't refer to the headnotes, which, as I said earlier, are prepared by the law journals and do not form part of the judgment. Now comes the most important part of the judgment, namely the reasoning and the conclusion arrived at based on such reasoning. It has often been said that reasons are the heart and soul of a judgment. The reasons for arriving at a particular conclusion should be clear, logical, absolutely coherent, and should reflect correctly why the judge has come to a particular conclusion. The litigant, the lawyers, and the appellate courts should be in a position to understand what you have decided and why you have come to a particular conclusion. Don't leave any loose ends and deal with all the submissions made by the advocates. Merely because you find it difficult to deal with a submission, as it comes in the way of a conclusion you have arrived at, don't ignore or omit such submission, as you would be doing injustice to the party. Record all the submissions correctly so that the party is not at a loss before the appellate court, which might question it if the submission does not find place in the judgment. Omitting a submission unless it is absolutely irrelevant results in injustice to the concerned party, as the appellate court would believe what is stated in the judgment only. The only remedy that is then available to the aggrieved party is to file a review before the concerned court, which unnecessarily prolongs the matter and causes financial as well as mental harassment to the party. The best judges perform their reasoning function honestly and to the best of their ability, without undue concern that an appellate court may find error or reach a different conclusion. While practicing as an advocate, I often heard the expression judicial dishonesty, which was with regard to non-recording of certain submissions advanced by an advocate if the concerned judge finds it difficult to deal with, given the view he wants to take in the matter, as it would make the judgment vulnerable in appeal. This kind of judicial dishonesty is best avoided. It is being just that should be uppermost in the mind of the judge when dealing with a matter, and one should not be concerned with the fate of his or her judgment in appeal. All that one should do is diligently and sincerely decide the matter to the best of one's ability, knowledge, and judgment, without fear of ever, affection, or ill will, which is the oath that a judge takes at the time of joining the judiciary. Given the fact that the primary audience of a judgment is the litigant, a judgment should be readable, clear, precise, unambiguous, and capable of being followed. Also, transparency is key. Justice should not only be done, but should also be seen to be done. Parties to the litigant need to understand the result and the mental, analytical process by which the judge arrived at the decision. After giving the reasons comes the final conclusion and the relief granted or rejected. See that there is clarity in the relief that you grant. The party should be clear as to what relief has been granted to the aggrieved party. An ambiguous judgment creates a lot of problems for both the sides. Once a judgment is dictated, it needs to be edited. Preparing a draft judgment is hard, but there is further hard work involved in editing the draft judgment. Good editing ensures that a judgment is lucid, thorough, coherent, concise, and has transparent reasoning. It identifies flaws such as the use of discriminatory language. Editing is a manifold task that should include using a checklist of topics or issues to ensure that the judgment embracing all that it should and that all issues are resolved. Checking names, dates, figures, and other data for accuracy. Eliminating repetition. Excluding irrelevant findings of fact. Pruning lengthy quotations of law, passages of transcript, or extracts from affidavits or documents tendered in evidence. Simplifying lengthy, complex sentences and adopting short sentences where appropriate. Checking the use of punctuation to avoid ambiguity and facilitate comprehension. Scrutinizing the length and contents of paragraphs. Of course, time is a factor in determining how much editing is possible. But even when a decision must be delivered urgently, some editing is still required, especially to ensure that the decision covers all the points raised for determination. Whereas when there is no immediate pressure of time, other than the imperative to deliver a decision as expeditiously as possible, a more thorough revision should be undertaken. The more a judgment is edited or revised, the better it will be. Even if the parties themselves do not persist and read the lengthy exposition of facts, the lawyers will usually do so, if only to test the judgment for the accuracy and fairness of its fact finding. Even if litigants do not fully understand the analysis of legal precedent and exposition of legal principles, their lawyers are entitled to have it demonstrated that the judge had the correct principles in mind and properly applied them. The legal profession is entitled to examine the body of judgments for the learning and the precedents that they provide, and for the reassurance of the quality of the judiciary, which is still the core of our administration of justice. It does not take long for the profession to come to know, including through the written pages of published judgments, the lazy judge, the judge prone to errors of fact finding, the judge without understanding the laws of evidence, the judge who has difficulties with complex propositions of law. It is principally through these pages of written judgments that quality may be assessed. Brevity, simplicity, and clarity are the hallmarks of good judgment writing. But the greatest of these is clarity. Judges with gifts of communication, writing in a simple and straightforward style, tend to have the greatest influence because of their clarity of expression. In my personal opinion, the most exciting and satisfying part of being a judge is writing a judgment. The more challenging it is, the more satisfying it is. In fact, I, for one, enjoy dealing with challenging matters, though it entailed a lot of hard work and perseverance. In these times, when there is a load of dockets and all judges are heavily burdened and hard pressed for times, one cannot spend as much time after a judgment as one would like to. Nonetheless, one should ensure that all relevant issues and points raised by the parties are dealt with by assigning proper reasons. Matters should always be decided on merits, no matter who the litigant is and no matter who the lawyer representing the litigant is. One party may be represented by a reputed senior advocate and the other by a ranked junior who may not be able to conduct his case properly, but that should not make any difference so far as the result of the litigation is. While every judge would like to be properly assisted by the learned advocate representing the party, nonetheless, if the concerned advocate fails to do so, that should have no impact whatsoever on the case of that party. It is the duty of the judge to study the case properly and take care of the fact that one side is not properly represented to ensure that a litigant who does not have the resources to engage a seasoned advocate does not suffer on that count. Ultimately, it is the judge who has to decide in accordance with law, and the judgment should not be impacted by the fact that one side was not properly represented. Some judges are inherently brilliant and have a great grasp over the subject and can effortlessly dictate judgments without having to work too hard, but not everyone possesses those abilities. Nonetheless, by dint of hard work, you can achieve the same level. The only difference is that you have to put in more time and work harder than them. One has to understand one's strong points and one's limitations and work accordingly because everyone has different levels of competence. But hard work and diligence is a great leveler. Always keep a pen and notepad handy. You never know when a bright idea relating to a case strikes you. If you don't jot it down there and then, there is all likelihood that after a while you may not be able to recall it. I have always maintained that the duty of a judge is to decide matters and not merely dispose them. It is the quality of your judgment that matters and not the number of matters that you dispose. While in these days where the workload is very high, numbers also matter, but not at the cost of justice. If in your quest for quick disposals, you do not decide a case properly, it results in injustice to the litigant, and you are merely disposing cases and not dispensing justice. At times, and these days quite often, we see judges suffering from what can be termed as disposal mania, where cases are disposed of in a jiffy without going into depth in each matter. At times, this can be justified when the issue is common and judge has to only apply the ratio of the decision of the High Court or the Supreme Court on the controversy in issue. Otherwise, such quick disposal may result in great injustice to a litigant who has waited for years and sometimes even decades for his matter to be heard, only to see the matter being perfunctorily disposed of in the name of a quick disposal. A judgment should not reflect a judge's personal prejudices and bias. The outcome of any case should be based only on merits and merits alone. Judgment should not be colored by personal beliefs and prejudices. What one has to look at is the law, apply the law, and decide the rights of the parties in accordance with law. However, people often get swayed by sentiments and personal beliefs, which clouds their reasoning and often results in injustice to the litigant, frustrating the very object of dispensing justice. The religion, the caste, the gender, the status of the litigant, etc., should never affect your judgment, which should be purely in accordance with law. The fact that you dislike a particular lawyer, or that he has argued more than necessary, or has managed to annoy you, or that you like and respect a particular lawyer, should not influence your judgment, which should always be decided on merits, as it is the litigant who is actually before you. Never think of the consequences of a particular view that you are going to take, so long as you believe that it is the correct view. A judge should always decide matters with conviction and courage, without worrying about what society will say, more particularly in matters involving issues which are in the spotlight and likely to be reported widely. As a lawyer, you may specialize in a particular subject or subjects and restrict your practice to those subjects and gain expertise in them. But a judge has no choice but to deal with whatever case he or she is assigned, no matter which is the enactment concerned and whether or not he or she is acquainted with such law. At the level of the High Court, the judgments rendered are followed throughout the concerned state and are binding precedents on the courts below and even on coordinate benches. Where a wrong judgment may set a wrong precedent, which can only be set aside by the higher forum, or a coordinate bench may refer it to a larger bench, which again adds to the workload of the concerned court. Therefore, if a judge is not acquainted with a subject, the first thing he is required to do is acquaint himself or herself with the legal position with reference to the binding precedents, etc., and carefully study the matter, understand the law and the subject he or she is dealing with before venturing to render a judgment. A judge renders justice through his decisions. The decision making culminating in the judgment is the heart and soul of the judicial process. Good judgments enhance the prestige of the judge and eventually the prestige of the judiciary. Bad judgments obviously have the opposite effect. Therefore, there is a need for judges to make a constant and continuous effort to render good judgments. Decision making is not about not about writing a judgment, nor does it begin when a judge starts hearing final argument. It pervades every stage of the case in making interim orders, in framing issues or charges, in allowing or disallowing questions in oral evidence, in admitting or rejecting documents, in hearing arguments, in analyzing the material and reaching a decision, and even in granting or refusing adjournments. In short, it is the way the judge behaves, conducts, and decides a case. Thus, the art of judgment writing encompasses not only the ability to write a good, reasoned, and interesting judgment, but also absolute integrity and fairness in dispensing judgment. I will end by reading an extract from the decision of the Supreme Court in CIT versus Saheli Leasing and Industries Limited, 2010, 6 SCC 384, where the court has reiterated a few guidelines for the courts while writing order and judgments to follow the same. The court has clarified that these guidelines are only illustrative in nature and not exhaustive and can further be elaborated looking to the need and requirement of a given case. I quote, "It should always be kept in mind that nothing should be written in the judgment or order which may not be germane to the facts of the case. It should have a correlation with the applicable law and facts. The ratio decidendi should be clearly spelled out from the judgment or order. After preparing the draft, it is necessary to go through the same to find out if anything essential to be mentioned has escaped discussion. The ultimate finished judgment or order should have sustained chronology, regard being had to the concept that it has readable, continued interest, and one should not feel like parting or leaving it in the midway. To elaborate, it should have flow and perfect sequence of events which would continue to generate interest in the reader. Appropriate care should be taken not to load it with all legal knowledge on the subject, as citation of too many judgments creates more confusion rather than clarity. The foremost requirement is that leading judgments should be mentioned in the evolution that has taken place ever since the same were pronounced, and thereafter, latest judgment, in which all previous judgments should have been considered, should be mentioned. While writing a judgment, psychology of the reader has also to be borne in mind, for the perception on that score is imperative. Language should not be rhetoric and should not reflect a contrived effort on the part of the author. After arguments are concluded, an endeavor should be made to pronounce the judgment at the earliest, and in any case not beyond a period of 3 months. Keeping it pending for a long time sends a wrong signal to the litigants and the society. It should be avoided to give instances which are likely to cause public agitation or to a particular society. Nothing should be reflected in the same which may hurt the feelings or emotions of any individual or society. Thank you. Stay safe and have a nice day.
Thank you, ma'am, for such an enlightening session. Now, with the permission of leadership, shall we take up some questions and shall
Yes,
we
of
open?
course.
Yeah,
Yes.
okay. Ma'am, there is one question. A girl named Rishika is asking that what should be the most important don'ts while reading or authoring a judgment?
I did again. What is the most
Ma'am,
important?
she is asking what should be the most important don'ts while reading
Don'ts.
or don'ts. Do and don'ts.
Acha,
Don'ts.
do's and all right.
Don'ts while reading or authoring a judgment.
While reading a judgment, there's nothing like don'ts because you have to read the judgment thoroughly and understand what it wants to say. But while writing a judgment, you have to be careful that you stick strictly to the facts of the case. Don't write anything unnecessary in it. Don't comment on your own, and don't let your own thoughts come into the your own personal thoughts and opinions come into the judgment. Your judgment should be strictly in accordance with law. You decide the issues which are before you. Sometimes some things that happen, in society might create an indignance on your part, and you might want to comment on something in your judgment, but it is best to refrain from commenting while writing a judgment. So let your judgment be restricted only to the issue before you and on the facts before you.
Thank you, ma'am. I'm sure that she have received her answer and she got the answer of her question. One more question, ma'am, is there that what is the thought process while dictating the judgment, and are there any other factors that affect the thought process other than the case document on merit?
See, there's nothing like a thought process or anything because, see, you read the matter, you understand the law, you hear the advocates, what they put forth before you, and you collate everything together, and then, of course, there is a thought process as to how you are going to decide the matter because you have to consider the viewpoints of both the sides and then come to a conclusion as to side, which side the balance tilts more in whose favor, and then decide accordingly. But that is the only thought process which comes into the picture, and nothing other than that, except the merits.
Yes, ma'am. Ma'am, there is one more question that she's asking that should a judgment be analytical based on our understanding or evaluative based on the material in front of us?
It should be analytically based on your own, on your understanding. Because, see, when you base a judgment on your analysis of your own understanding, there is more clarity in it.
Right.
Because then you put into the judgment what you have understood. So, the person, the reader, would be able to understand you better if it is more analytic and what you have understood is put in your judgment. That is actually how I used to write my judgments. I don't know how clear they were, but whatever I understood of a subject, I used to put it in the judgment.
Right. Thank you. Ma'am, there is a similar question like previously I asked that one girl is asking that what is the most efficient way of reading long and detailed judgment?
Efficient way of reading, I don't know. I mean, see, normally when you read a judgment, one reading is never enough because unless you read it, I mean, to really understand the actual purport of a judgment, you sometimes need to read it over and over again. But at least I have a habit of marking what I find is important and then read that part again and again to understand. And it's the ratio decidendi part which is the most important. So you should concentrate on that part and the facts which led to that reasoning and the actual reasoning for coming to that conclusion. That is the most important part of the judgment. But overall, you have to read the entire judgment to understand the context in which the judgment has been rendered.
Ma'am, there is one more question we have. If, with your permission, shall I ask?
Yes.
There is few more,
Yeah.
questions. Ma'am, there is one question who is asking that how does the delivery diversity of opinions be managed while delivering a judgment as a part of a division bench?
See, normally in a division bench also, the question of diversity comes very rarely because normally the law is very clear and it has to be decided in a particular manner. But otherwise, if two judges disagree and they can't, I mean, even if after trying to convince each other, can't convince each other to take one point of view, then of course there's a dissenting judgment which then has to be sent to a larger bench to decide who of the two judges is correct. I mean, but otherwise, there's not much divergence in a division bench between judges.
Okay, ma'am, thank you. There is one question which is what is the way out to prevent conflicting judgment delivered by apex court? What is the way out to prevent conflicting judgments delivered by apex court?
See, there the advocates have to be fair because when is a conflicting judgment rendered? When the court is not aware of an earlier judgment taking a view on the matter. Because be it the High Court or the Apex Court, judgments of a coordinate bench are binding upon them. So unless a judgment, even in the High Court, you come across conflicting judgments because the earlier judgment is not brought to the notice of the bench when that while delivering while hearing a case. Therefore, then conflicting views arise. But if a bench knows, if a judge is aware that a particular view has been taken, then he is bound by that view. And if he does not agree with it, he has to refer the matter to a larger bench. He on his own cannot take a different view. So conflicting views come when advocates are not fair or advocates have not done their homework properly and pointed out to the court the fact that there is already a decision on the point.
Right. Thank you, ma'am. Ma'am, there are so many questions, but one
All
I
right.
ask
Yes.
is it necessary to write a lengthy judgment? How necessary it is to discuss all points at length?
See, it's not necessary to write a lengthy judgment, provided you have the ability to write precisely. I've come across some brilliant judges who could put things in very precisely, the same ability which I may not have. So my judgments might be lengthier than the judgments rendered by that. But the thing is, your judgment should deal with all the submission. If you have the ability to do it briefly, I mean precisely, well and good, then you can do it. Every judgment need not be lengthy. It depends upon your ability and your competence to be able to discuss the matter and decide. But your decision should not be incorrect, and you should be fair and decide and deal with all submissions made.
Thank you, ma'am, with your enlightening session and this open floor. There are so many questions which is automatically, getting answered with your session and the open floor. Now, with the permission of her ladyship, shall we move to the result declaration ceremony, ma'am?
Yes, yes.
So here is the time for the most awaited result declaration ceremony of Virtual National Judgment Writing Competition 2022. With the permission of her ladyship and ma'am, shall we announce the winners?
Yes.
So we are going in a descending order. So there are three categories of the awards: the second runner-up, first runner-up, and winner. So we are going accordingly in the descending order. So the second runner-up trophy goes to TM14, Faculty of Law, Jamia Millia Islamia. The first runner-up trophy goes to TM13, Kids School of Law. And the most awaited trophy, that is the winner trophy for Virtual National Judgment Writing Competition 2022, the Team 20 Christ University Delhi bagged this prize. Congratulations to all the winners and all the participants. Thank you so much for participating in Virtual National Judgment Writing Competition. Every event call for a good end, and it's time for an official vote of thanks. And for it, I would like to invite Dr. Vidisha, Assistant Professor, GLS Law College, Faculty of Law, GLS University. Vidhi ma'am, over to you.
Thank you, Jia ma'am. Very good morning to Honorable Miss Justice Harsha and Devani, all the participants, and especially a congratulations to all the winners of the National Judgment Writing Competition. A very special thanks to Harsha ma'am for sparing the valuable time and enlightening the student with a very minute aspect of the judgment writing. Ma'am, it is those who are very clear they want to go into the judiciary. For them, it is very helpful. Ma'am, very rightly and precisely stated that judgment writing has to be very clear, simple, unambiguous, lucid, and very concise. Thank you, ma'am, for all the enlightening the session. Uh, Also, the special thanks to the jury. Mayuri ma'am rightly stated that Justice A.L. Dave sir, it has been very minutely checked. All the judgments were very minutely observed from the cover page title to the arguments which were dealt by the advocates to the observation of the honorable judge. So, thank you to the jury member for evaluating the judgment. Very special thanks to Mayuri ma'am, the backbone, for all the support, never-ending support for all the events. Thank you very much, ma'am. Special thanks to all the viewers of the students and the participant for a patient hearing. Thank you once again. Thank you.
with the permission of leadership, shall I end the session? Thank you
Yes,
so
yes.
much, ma'am,
Okay, thank you,
for
sir.
Thank you, ma'am.
the part.
Thank
Thank you,
you.
ma'am.
My pleasure.
Thank you.
Should I leave now?